Hi there, I'm Christine Van Gyn, and this is the Canadian Constitution Foundation's Freedom Update. Today I want to give you an update about our case fighting the Trudeau government over their illegal invocation of the Federal Emergencies Act and how the government is now refusing to disclose documents to explain why they invoked the act. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine Van Gyn, and I'm the Litigation Director for the Canadian Constitution Foundation, a Canadian legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. And if you ring the little notification bell, that will make sure you never miss one of these updates. Also, please remember that my videos are not legal advice. If you have your own legal question or problem, please consult your own lawyer. So as I've outlined in some of my previous videos, which I will link to below, we've brought a court challenge to the federal government's illegal use of the Emergencies Act in response to the Freedom Convoy protests that took place in Ottawa in early 2022. In our court challenge, we are arguing that the criteria to use the Emergencies Act, which is extraordinary legislation that gives the federal government really incredible powers, that criteria was not met. And the orders issued under the Emergencies Act were an unconstitutional violation of Canadians' civil liberties, and that existing legislation, like the Criminal Code, could have addressed the situation in Ottawa. The Canadian Constitution Foundation is not the only organization fighting the government over this. There are actually 4 organizations bringing similar cases, including the Canadian Civil Liberties Association, and the Alberta government is intervening to oppose the federal government as well. But in order to answer really important legal questions about the government's use of the Emergencies Act, which we say was illegal and unconstitutional, the court needs to have access to the full and complete record. And the public record that's currently available is insufficient and sparse. The Trudeau government did present a weak official explanation for the proclamation of the emergency. They did that because an explanation is actually required by Section 58 sub 1 of the Emergencies Act. But the explanation that they provided is really nearly laughable. The document, which was tabled in Parliament, is unsigned and unsworn, and it relies on things like CBC News reports and hacked data with no chain of custody. Now, this cannot be sufficient to declare a state of emergency with a massive impact on our civil rights. There was one thing in that official explanation, though, that piqued our interest. The official explanation mentions to quote, robust discussions at 3 meetings of the Incident Response Group on February 10th, 12th, and 13th of 2022. Now, the Incident Response Group is a committee of cabinet which serves as a dedicated emergency committee to advise the Prime Minister, Justin Trudeau, in the event of a national crisis. However, the government is refusing to produce the minutes of these meetings, even in the face of our challenge that we've brought. In order to block this disclosure, Prime Minister Justin Trudeau is actually relying on a law shielding government secrets, Section 39 of the Canada Evidence Act. And in a fascinating historic parallel, this law was actually enacted by his father, Pierre Elliott Trudeau, in the years following his use of the War Measures Act. So what exactly is it that the government's preventing the public from seeing? First, they have omitted altogether those minutes from the Incident Response Group and Cabinet. This should contain the details of that robust discussion that the government has said occurred on February 10th, 12th, and 13th. Second, the government is withholding the Minister of Public Safety's submissions, which provided the factual and legal basis for the Emergencies Act to be used, and the orders under it. like, for example, the freezing of bank accounts or the creating of a new crime of participating in a public assembly that may lead to a breach of the peace. As a result of the government withholding these documents, the record that the court will see is nearly silent on the central legal questions in the application for judicial review. That's our court challenge. And the central legal question is whether the cabinet had reasonable grounds to believe that the blockades in Ottawa could not be effectively dealt with under any other law of Canada, and whether those orders, like the freezing of accounts and that new crime of participating in a public assembly that may lead to a breach of the peace, well, whether those measures were necessary. The record as we have it now only contains a single conclusory sentence on this point, which says the ongoing Freedom Convoy 2022 has created a critical, urgent, temporary situation that is national in scope and cannot be effectively dealt with under any other law of Canada. Now, this single sentence is clearly not enough to justify the use of the Emergencies Act and to create these extraordinary powers, these extraordinary orders that the government enacted. So we want to know what the real basis was, if there was one at all, because we think there was no basis. By withholding the details of these documents, the government is putting the court in an impossible situation. In order to discharge its constitutional function, the court must have the full record. Without these materials the government is withholding, the court will be put in a position of basically acting as a fig leaf for the Trudeau government. So what are we doing? How are we going to push this case forward? Well, at the Canadian Constitution Foundation, we have brought a motion asking the court to order the government to disclose this material. We're asking for the court to order the government to deliver the minutes from cabinet and incident response group and any other items listed in the Section 39 certificate. We want those materials on a council-only basis under a confidentiality undertaking. Does the court have the power to order this? We say it does. We're arguing that the federal court has plenary powers under common law to control the integrity of its own process as a part of its core function to preserve the rule of law. For judicial review to be effective, meaningful, and fair, a court must have access to materials before the decision maker, which can be tested in an adversarial proceeding. Without this information, there may be gaps in the evidentiary record that may leave the government unable to demonstrate the reasonableness of its decision, or it may undermine the requirement that there be a reasoned explanation for the decision of the government to invoke the Emergencies Act. Council-only access, which is what we are asking for here, has been used in the past, although it's been used in a different context of dealing with claims of national security rather than cabinet confidence. For example, in the Air India prosecution, the prosecution in that case permitted defense counsel to access withheld material on an undertaking not to disclose that material to the accused. Basically, by refusing to provide these documents, even on a counsel-only basis, the government is asking the court to just accept their say-so, to trust them. And as our lawyer, Sujit Chowdhury, has said, that's just not how we do law in this country. Our challenge to the government's confidentiality claim is expected to be heard in late May, and the broader challenge to the federal government's use of the Emergencies Act will be heard in the early summer. Now, this case is one of the biggest cases that we're doing this year, and it is a tremendous amount of work. And we've hired some of the best lawyers in the country to do it. It's an expensive case, though, but it's one that will be precedent setting, so we think that it's worth it. It's precedent setting because this is the first time that the Federal Emergencies Act has ever been used, and we need to stop the Trudeau government from normalizing the use of emergency legislation. So if you care about this case and you want to help us hold the Trudeau government to account, please consider making a donation to help us pay for our legal fees, which we expect will exceed over $100,000. You can make a tax-deductible donation at THECCF.CA/donate. Now, I understand times are tough for a lot of people, so if you can't make a donation, I totally get it. But please share this video on your social media platforms. We are a charity and we're entirely funded by the generosity of our donors. And I really, truly appreciate everyone who donates, who shares this video, who likes this video. Every little bit helps us to get our message out and to do cases like this. If you want to stay up to date about the case as it progresses, you can subscribe to this channel by hitting like and subscribe below. You can ring the notification bell. That way YouTube will let you know as soon as a video has been uploaded and you won't miss any updates. You can also sign up for our Freedom Update mailing list at THECCF.CA/freedom updates. And that way you will hear about every update as this case proceeds. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.